Good afternoon, everyone. For those of you who don't know me, I am Lanisha Lakeborn, the Business Development Manager for Asset Management and High Net Worth Services at the Bermuda Business Development Agency, also known as BDA. The BDA is an independent public-private partnership, and our focus is on promoting the jurisdiction and encouraging economic development and inward direct investment. We have teamed up with Step Bermuda for a series of webinars. Today, we bring together one of the jurisdiction's experts to discuss Bermuda property, stamp duty, and land title registration for Bermuda-based trustees. Thank you again for joining us, and I will now hand it over to the chairman of Step Bermuda, Ashley Fife.
Many thanks, Lanisha. Here at STEP, we're very pleased to be working with Bermuda Business Development Agency on these presentations. As Lanisha mentioned, we have a property expert and a good friend of mine, Neil Molyneux of Appleby. Neil's got extensive experience, I'd say more than 25 years and more than 10 practicing in Bermuda. He's also worked for long periods in the UK and even a brief sojourn in Turks and Caicos. And Neil is presenting on what I think is quite a challenging topic, and we're very grateful for Neil to be presenting to us. And I'll let Neil take it from here.
Thank you, Ashley, and thank you, Lanisha. So this presentation is not intended to cover all aspects of land law scenarios, but should cover those commonly encountered by local trustees. I'll start off with transfers of real estate into trust. Nowadays, with primary family homestead available, transfer of family property into a trust is unusual unless the family own multiple properties. Historically, many properties were transferred into trusts to avoid stamp duty, otherwise known as death tax. Using primary family homestead, however, death tax can be avoided on one property. Hence, since primary family homestead was introduced, the transfer of one property with the expense of trusts is often seen as economic. So really, trusts are only for multiple properties. However, recently, I have noticed some US settlers transferring property into trust for Bermudian spouses and children, where the settlor is not a beneficiary. I suspect this is driven by US tax considerations rather than local tax. Otherwise, as I say, transfers of Bermuda property into trusts is fairly rare. There's also one other consideration here, in that appropriations of Bermuda property into trusts suffer a much larger stamp duty on them, as opposed to a normal conveyance into trust. Therefore, if you have US dollars you can use to transfer into the trust and then buy the property, that's probably more stamp duty efficient. So again, advantaging US settlers or foreign settlers rather than locals. What is more frequent is a transfer out of trusts. With the ongoing costs of maintaining a trust for a single property, it's common to appoint out the property by way of a voluntary conveyance from the trustees to beneficiaries. As long as each beneficiary receives 100% of their individual entitlements, the tax commissioner should adjudicate no stamp duty is payable on that transfer. Unfortunately, as I say, voluntary conveyances have to be submitted to the tax commissioner for adjudication, and this can take a long, long time, from 6 months to, I have known, a handful to even 10 years. I recently got one back from 2011. The exemption from stamp duty for transfers to the beneficiaries is covered by Section 39(3) of the Stamp Duties Act 1976. So it's not an exemption under the head, it's part of the General Act. Often people therefore miss that exemption. Ashley has in the past pointed out many Bermuda trusts are discretionary trusts with no beneficiary having any interest at all in the trust property until the trustee exercises discretion to distribute. So this means in a transfer out of trust, the trustee has freedom to ensure no stamp duty is payable on the appointment. And to do that, you simply alter the trust to establish that the beneficiaries who are going to get the property are the ones entitled to the whole of the Bermuda property. The appointment out of trust is by way of a deed of appointment or a voluntary conveyance or both. You may prefer to keep the deed of appointment out of the public domain. Typically, the Office of the Tax Commissioner will see anything that's sent in to do with the trust for land tax purposes, and as well there's land title registration issues. So using a voluntary conveyance, which deals only with the Bermuda real estate element, the secrets of the trust are maintained. Additionally, voluntary conveyances are easily understood by property attorneys who are often not trust experts, and perhaps more importantly, the tax commissioner sees the voluntary conveyance as a discrete document and it's not clogged up with other issues which may slow down the adjudication, or the tax commissioner may think stamp duty might be due upon, and then there's sort of an argument which takes years and years to resolve. As long as there's no stamp duty payable, these voluntary conveyances are pretty straightforward, with an all-in cost of around $3,500 at par scale. So that includes the $202 application fee to the tax commissioner and registration of the documents as a land transfer. If, however, any person or beneficiary receives more or less than their individual entitlement under the trust, and there's no reason why they should, if the trustees have discretionary power to designate beneficiaries, or if they don't do it properly, then stamp duty will be payable on the element of value of the property that goes to the person not entitled to benefit under the trust. The next subject I'm going to mention is change in trustees. A change in trustees is affected by a DORA, a deed of retirement and appointment, and attracts stamp duty at $100 with $25 on each counterpart or duplicate. A conveyance of property from an outgoing to new trustees attracts stamp duty of $200. Also note that under Section 30 of the Trustee Act 1975, there is no specific need to mention property transfers, since the 1975 Act provides that unless in specific circumstances, such as land subject to a mortgage, land subject to a lease, land subject to covenants, that in those there's no need at all to mention the property or the transfer of the property. It automatically happens under the 1975 Act for all transfers after 1975, except in those scenarios that I've mentioned. This creates the question Ashley helpfully raised: does a DORA under which Bermuda property automatically passed under Section 30 attract stamp duty of $200 under Head 18 or $100 under head 21? I don't know the answer to that question, but for safety, I would attach $200 of revenue stamps. This then makes no odds if the tax commissioner sees it and adjudicates it for 100. Well, you've only lost $100, but you brought certainty in case the tax commissioner goes for the higher figure. And the way tax commissioner decisions are made lately, I would go for the 200. Obviously, the tax commissioner is looking after the interests of the government, and the government wants to collect in as much money as it possibly can. If trust property is being transferred subject to a mortgage, the outgoing trustees should insist on a release from the mortgagee so that no further liability attaches to them, since they'll have lost control of the assets of the trust. This is achieved by including the bank as a party to the DORA, and you would also incorporate wording to novate the mortgage with the bank's consent from the outgoing to the new trustee. The bank will likely want to ensure that the beneficiaries are also guarantors for the mortgage, but that's a separate issue. Next, I move on to the sale or purchase of land. It's more usual these days for trusts to sell land rather than purchase, except as noted earlier, perhaps with US settlers acquiring property for trusts. Sales usually attract standard sales commission of 5% to the realtor and legal fees on a time spent basis. And often the selling trusts pay half of the purchaser's costs at bar scale, and that would include the stamp duty at up to 7%. Under the terms of the Conveyancing Act, only one trustee is required in order to give a proper receipt for the purchase proceeds, unless the settlement requires otherwise. Next, letting property. Trust property can be let commercially and is sometimes let to beneficiaries on favourable terms. Sometimes the beneficiaries are also agents for the trustees. All dealings with beneficiaries should be documented to ensure responsibilities such as arranging insurance and maintenance are recorded. Perhaps insurance ought to be arranged directly by the trustee. The question has arisen in the past, what is the difference between a lease and a license? Essentially, there is no difference for practical purposes. The licensee gets the property, the tenant gets the property. However, under a license, I try not to use the word tenant because that's to do with a lease, but the person in occupation has certain rights under a lease that they don't have under a license. So under a license, they're said not to have security of tenure for the term of the lease. So a license is much easier to end because a lease, the only way to get the occupier out under a lease is by way of a court order. A license must carefully reserve rights for the landlord so that the occupier does not have exclusive possession. Exclusive possession could well cause the license to be seen as a lease and require a court order to remove the occupier. Mortgages are most often required to pay for purchase, maintenance, and/or improvement of trust property. Stamp duty is on a sliding scale, usually 0.25% for mortgages of 400,000 or less, or if for more, at a rate of 0.5%. Trustees should insist liability to lenders is limited to trust assets. For that reason, as I mentioned earlier, lenders usually insist beneficiaries act as guarantors for loans. Stamp duty on a deed of guarantee is $100 under head 21. About 2.5 years ago, land registration was introduced in Bermuda. It's had a disproportionate effect on trustees because prior to that time, trust documents could remain fairly secret. However, the Land Title Registry Office has insisted on seeing trust settlement documents and changes in trustees. So these documents have to be submitted with the application, but the Land Title Registry has insisted it doesn't keep copies and will return the copy documents that are sent to it to do with the trust. However, the Land Title Registry Office is also insisting that commissioners for oaths certify the trust documents as true copies, and therefore trusts without lawyers working for them are at a bit of a disadvantage here, because the previous certifications given, if they're not given now by a commissioner for oaths, are not valid in the eyes of the Land Title Registry Office. Despite land registration, the Land Title Registry Office recommends deeds are kept as evidence of boundaries in case of disputes with neighbours. This is because the Land Title Registry does not guarantee boundaries, and the plans it produces in any case are poor. Next, I'll move on to restricted persons, and for this you should read non-Bermudians, or people who aren't spouses of Bermudians at least. So, restricted persons cannot generally acquire an interest in Bermuda real estate without a land license under the Immigration Act. As beneficiaries pass down through the generations, it's often the case that, say, grandchildren are non-Bermudian. It's therefore important trustees keep details of beneficiary status up to date. Trust deeds should and often do provide that non-Bermudians are not entitled to benefit from trust property comprised of Bermuda real estate. If a trust does not contain such a provision, the settlement should be varied to incorporate such a restriction. If it does transpire restricted persons are entitled to benefit from Bermuda property, the trustee should on discovery attempt to vary the trust or obtain a deferral certificate and/or apply for an immigration license. A deferral certificate will allow the trustees to dispose of the non-Bermudian will allow the trustees to dispose of the Bermudian asset, usually within 3 years. A license, however, is expensive at 8% of the value of the property in which the non-Bermudian has an interest. You should note, immigration licenses are only available for the most valuable property, i.e. those with an ARV over $123,000. In the event a Bermudian dies owning land in Bermuda and the executor or administrator is not Bermudian, a deferral certificate is also required. Government currently charges $275 for a deferral certificate, and generally deferral certificates allow 3 years for disposal of the Bermuda land. At this point, I will say that immigration licenses have historically taken from 4 to 8 months to obtain, but there's a new system in place now, and they are coming through super fast at less than 2 months. A deferral certificate usually takes up to a month, sometimes less. And now I'll move on to stamp duty generally. All documents that fall within the instruments chargeable with stamp duty under the Stamp Duty Act and its schedules that are executed in Bermuda or brought into Bermuda are liable to stamp duty. Documents that are brought into Bermuda are liable for the duty within 30 days of bringing in. And generally speaking, all documents once signed in Bermuda face a duty payable within 30 days, unless the document is statutorily exempted. Documents or copied documents brought into Bermuda then should be stamped within 30 days. I would say perhaps if you get a document emailed to you, that you have to email that copy within 30 days if you don't already hold an original that's been properly stamped. Documents out of time for stamping should be submitted to the Tax Commissioner for adjudication. I mentioned delays at the Tax Commissioners earlier. A penalty and interest is likely, and there is the adjudication fee, which is currently $202. So it's a big hassle putting documents late into the Tax Commissioner. In addition to those penalties and the adjudication fee, perhaps the biggest penalty is just the delay while the Tax Commissioner takes a few years to look at the document and adjudicate. Often law firms are asked to prepare documents for trustees, and the drafts or the final signature versions are sent to the trustees' offices away from the lawyer's control. The trustees sign and date, but then forget need for revenue stamps. If in doubt, please ask the lawyer how much to stamp documents. For trusts, stamp duty is often, but not always, $100. But particular caution should be made with deeds transferring Bermuda property, or if the trustee accepts Bermuda property from a settlor by way of deed of appointment from another trust, as these may be subject to ad valorem duty. That concludes my script, but before questions, I have to thank Ashley for holding my feet to the fire before this presentation regarding matters of particular interest to the trust fraternity, and which I've hopefully now covered. But if you've got your questions, Ashley, I'm now ready. Thank you.
Many thanks indeed, Neil, and that's very kind of you. That was a very succinct and clear talk, and I'm glad I held your feet to the fire. You did a great job. I just wanted to emphasize that the point that Neil's talk is focused on Bermuda property, and I think when we're dealing with transfers in or out of trust, or from one trust to another trust where there's Bermuda property involved, we have to exercise particular care, and I think it's important that a property lawyer such as Neil be involved. The treatment of stamp duty on doors where, for example, an exempt company holds property that isn't Bermuda property under the Stamp Duties Act results in more favorable treatment because of an international business exemption. I just wanted to pick up on a couple of things. I think Neil's answered most of the questions that I had. So we're talking about a DORA where with Bermuda property involved, you stamp it with $200 to be on the safe side. It's not the case that you would, for privacy or other reasons that you mentioned with respect to deeds of distribution to beneficiaries, do a separate vesting deed in addition to the DORA. That's not the practice as far as you're aware.
Well, this is where trust lawyers and property lawyers kind of lose touch with each other, because to a property lawyer, the transfer of the real estate is by way of what's called a voluntary conveyance. Perhaps a vesting deed is more a transfer from trustee to trustee.
Sure, and as you said,
essentially they're all the same thing, and you have to be careful on all of them that you get the right level of stamp duty.
Sure, and I just had a couple of other observations. So we talked about where there's a discretionary trust and varying the trust to ensure that beneficiaries that you want to receive the property are entitled. Often it's the trustee just exercises a power under the terms of the existing trust, which essentially enables it to vary the trust or exercise the power of appointment so the property is distributed to the particular beneficiary in mind. So just as an observation, I suspect that you could have just achieved that in a deed of appointment itself, rather than doing a separate deed of variation. And I just wanted to clarify that.
Yeah, I agree. That sounds like a fine way of dealing with it. Just as long as the trustee has something documented that if the tax commissioner calls for it, it can be demonstrated to the tax commissioner that the correct people have received the property and they are indeed the correct beneficiaries.
And another point that you helpfully mentioned is where there's a mortgage involved, retiring trustee may require the consent of the bank mortgagee under the terms of the mortgage in order to change trustees. And you mentioned that the bank could be joined as party to the deed of retirement and appointment. And I agree with that. As a practical observation, I suspect that banks often don't want to be that involved with trust documents themselves. So we might often see the bank not a party to the deed of retirement and appointment, but a separate deed of novation whereby the bank releases the retiring trustee and the incoming trustee assumes the obligations of the retiring trustee under the mortgage. That's just an observation and just an example of how there can be different ways of doing things depending on the context and what parties wish for.
Effectively, it's all the same thing, that the outgoing trustee gets released, the new incoming trustee takes over the liability, and that the bank's covered.
Yes, definitely. And my final observation is, Neil can relax, this isn't a question for Neil, but one thing that I think a lot of trust practitioners will note, that there's a lot of time spent by practitioners working through what duty may be payable in circumstances where often it's a nominal stamp duty, might be the difference between $100 or $200. But nonetheless, it can be a painful exercise and perhaps an inefficient and cost inefficient one. One of the things that STEP is certainly exploring and with input from the Bermuda Business Development Agency is trying to extend exemptions to local trustees so that they apply more broadly, so we can cut through and perhaps do away with these nominal amounts of stamp duties. But there's certainly, that would be perhaps great for international business, but there's obviously wider factors to take into account. I just wanted to give a quick plug to Andrew Holden, who's giving a presentation on firewall legislation on the 26th of February at 1 p.m. Bermuda time. So look out for that. And there's certainly more STEP presentations with partnering with Bermuda Business Development Agency underway. So with that, I'll just thank Neil again. As I say, it was a difficult topic and I thought you were very clear, and many thanks for addressing the trust questions I put to you. Thanks again to Bermuda Business Development Agency. All the best.
Thank you.